Oh, I'm storing.
No, no, you're fine.
I didn't realize that anybody was behind me.
Good morning, afternoon. It is afternoon. We spent so much time on the floor this morning that, the whole day seems to have slipped by me. Good morning, I say it twice. Good afternoon. We are going to do a walkthrough and hear from the reporter of the bill on S210, which is an act relating to autopsy reports. And recent bill that was sent over from the Senate, and we have ledge counsel here. We have the report of the bills, Senator Cummings. So welcome to House Human Services, Senator Cummings.
Thank you.
The floor is yours.
Thank you. Get my head from
Yeah.
property taxes, which we just did on the floor, to autopsies.
Big difference.
This was an interesting bill. It was brought to us by Senator Hardy, and it reflected an issue that one of her constituents had. The constituent came in, she did not give her name, but her story was that her daughter had two children. The father of the two children had been absent for a number of years. The daughter died one night. The father of the children came back from out of state, picked up his kids, had himself declared guardian of the kids, took them out of state. So there was a lot of pain. And again, I think we realized we're only hearing one side of this story. In the meantime, because of the way the law works, only the daughter's immediate descendants, which would have been her children, and thus the ex-partner as the guardian of those children, could get the autopsy report. So this mother is left not knowing how her daughter died or why her daughter died. And it was very painful, story to listen to. And so the bill basically said you could go to court and you could, for good reason, get a copy of the autopsy. Sounded fine. Then we had Judge Zone come talk to us. And he put a little reality into the discussion. And the bill that is before you is the suggestion of the judge and has been run by the State's Attorneys Association so that it allows access, but with the ability to require confidentiality, it gives them some flexibility, but also the ability to set limits on. You may not be able to get the entire autopsy report. Maybe the mother doesn't need to know that maybe the daughter was pregnant with somebody else. There are things that deceased person may not want to have come out, and that the legal process has the ability to limit the entire autopsy, how much of the report you get, who gets it, to put disclosure requirements or non-disclosure requirements on it. So that we think these are probably rare circumstances. We think the bill doesn't open the door a whole lot, but it does allow something for the rare times that somebody really does seem to have a right to know what happened to a loved one. The last time I heard stories like this was when we were doing civil unions, and somebody's parents came and had the partner's body removed from the grave and took it home to be with them in New Hampshire because the partner had no legal standing at that point. So that's the kind of, I think, we're hoping to prevent.
Sure. Thank you. Are there questions for Senator Cummings? Yes, go ahead, Rep. Donahue.
I was wondering about, understanding the source. I was wondering about the, one of the criteria and source of that is, whether the disclosure is necessary for the public evaluation of governmental performance.
That's the one thing that I think we kind of got our attention. And this was suggested again by the state attorney's work. And the closest I could come to wrapping my head around it was perhaps you have a law enforcement agency that wasn't reporting things, or perhaps there were more than a normal number of deaths among a certain group in a state facility, that might be a reason where someone would want to investigate why is that happening.
I thought it was I thought that was a really good, it's very protective because it's through the judge and so forth, and the countervailing things that might mean forget it, but I think that's important.
We shouldn't be shielding our bad actions or governmental bad actions from being exposed.
Any other questions? Thank you, Senator Cummings. Appreciate it.
Thank you.
I'm going home,
Have a good weekend.
but I was here until 6 o'clock a couple nights.
Oh, yeah.
Have a good day.
That's a good, you too. Katie, can you join us and just run through the bill with us?
Good afternoon.
Good afternoon.
Katie McGlynn, Office of Legislative Counsel. We have S-210 from the Senate. Let me pull it up. Okay. So as you know, this is a bill about autopsy reports. Under really federal law now, HIPAA governs who can get an autopsy report, and we don't have any language really in state statute that sort of restates federal law as to who can access an autopsy report. This bill creates a secondary avenue that is HIPAA compliant, that creates a court process for somebody to obtain an autopsy report who isn't otherwise authorized to get the report under HIPAA. So as I have structured other things, this bill has a new subsection B. B1 restates federal law that you can obtain an autopsy report in compliance with HIPAA. And then the exception or the new path is created in B2, the court process. Before we look at the language, I'll say that the committee downstairs, I think the witness that provided them the most guidance on this was Judge Zone. And he suggested that the committee look at Wyoming statute. And so, for example, the language you brought up was from the Wyoming statute. So some of the suggestions he gave around the court process was to provide parameters for the judge making the decision about how to make the determination to give the autopsy report, to allow for portions of the autopsy report to be redacted, and to have some limitations on whether the autopsy report would be distributed. So that's where a lot of the changes came from. And at the end of this process, I was sort of acting as an intermediary to get the various parties on one page. So I think by the time it left the Senate, at least, Judge Zone, the health department, and the state's attorneys, everybody had ended up on an agreement on that subdivision 2. I don't know if that has changed, but it was the case a couple weeks ago. I think that's all I have to tell you about that. So let's jump and look at the language. So B1, again, this is sort of restating existing federal law that the Office of the Chief Medical Examiner shall disclose a decedent's autopsy report to the decedent's personal representative in compliance with HIPAA and its associated regulations, including to the court-appointed executor or administrator of the decedent's estate and the decedent's heir law. Nothing in this subdivision is intended to preclude disclosure of a decedent's autopsy report to other individuals as authorized by federal law. So then we're creating this new path. Subdivision 2 is what is a new way for somebody to obtain an autopsy report if they can't otherwise get it under HIPAA. So in subdivision 2, an individual who is not authorized to receive the report pursuant to 1 may petition the probate division of the Superior Court for a copy of the autopsy report. The petition shall contain an affidavit attesting to the petitioner's relationship to the decedent and the reason the petitioner is seeking the autopsy report. The petitioner shall notify the office of the chief medical examiner and the state's attorney of the county in which the death occurred within 5 days after filing the petition. Then there's an opportunity for notice. The office of the chief medical examiner and the state's attorney have an opportunity to respond within 14 days after that notice. If the Superior Court finds that the petitioner has demonstrated good cause for the petitioner to obtain the autopsy report and the state's attorney does not object, it shall order the office of the chief medical examiner to provide a copy to the petitioner in whole or in part. So that's the option to redact, and may place restrictions on the petitioner's dissemination of the copy provided. So that could be, you may have it, but you may not distribute it to somebody else. And then in subsection B, we have a definition as to what is meant by good cause. The petitioner has to demonstrate good cause to obtain the report. So a court in determining good cause would consider the relationship of the petitioner to the decedent and decedent's family, whether the disclosure is necessary for the public evaluation of governmental performance, the seriousness of intrusion into the decedent and the decedent family's privacy. Top of page 3, whether the disclosure is by the least intrusive means available, including whether and to what degree redaction of some portions of the autopsy report is appropriate, and the availability of similar information in other public records regardless of form. And then we have a July 1 effective date.
So Katie, do all of those things have to be present?
These are I would guess Judge Lenny would have a much better way to answer this,
Okay.
but when a judge is making a decision, they're balancing. So these are factors that are sort of part of that balance.
Okay, Representative Eustace and then Don.
So I just simply don't know. Can you give me an example of what small 2 is? A public evaluation of governmental performance?
Maybe the handling of a police investigation after a
I see.
suspected murder, something like that is what comes to mind.
Okay.
I'm
Just
sure
need-
there
I
are
just
other
need- I just-
examples.
Well, I was thinking first went to taxes, but.
Oh.
You never know.
Well, it's almost April 15th. Representative Donahue.
Yeah, I'm looking at lines on page 2, lines 7 and 8. I'm sorry, no, the line 9. If the Superior Court finds good cause and the state's attorney does not object,
Mhm.
and then there's no avenue of what happens if they do object. So does that imply if the state's attorney objects, it's dead in the water,
Yeah,
no matter how significant the good cause is?
yes, and that was,
So it would expose wrongdoing in the state's attorney's office. Couldn't release it.
that's how I would read it. It was added at the request of the state's attorney, so you may want to hear from them.
Well, another opportunity to have Tim in, unless the state's attorneys have their own association that I'm not familiar with.
Right.
Okay, that's I think a good point to raise, because it's like a veto power.
Right, right. And I could see it being a factor that the judge would, if the state's attorney is objecting, well,
Right.
that's got to be a significant factor as to why and in weighing it. But yeah, it's an absolute veto power
Right, and
over the judge being able to even look at the evidence.
I get that, yeah, which seems like too much authority to me, I'm just gonna say, at the reading of it. we'll hear from
Right,
them.
right.
But I suspect it's with, regard to, aspects of a criminal case or something, but I think it's
Because then they make
it's
the
too
case,
absolute,
they
right?
make their case to the court as to why
Yeah.
it shouldn't be released because of,
Because of,
Yeah.
right? I mean, I can see them having an opportunity to review, I guess, and state the reasons, and then the judge should be the one making the determination, I think, but okay. Anybody have any other questions for Katie about content of the language? Go ahead, Representative Bishop.
First question would be autopsies. It says it's whether the Superior Judge or Attorney General orders an autopsy. Do we have a sense as to
This is an existing.
existing
Okay.
language? Yeah, starting with line 6.
Thank you.
Page 1.
Are they the only two entities that?
Yeah, and I'm just wondering, in what
Orders and
instances, is this only in criminal instances? Do we have, don't know when autopsies come about?
yeah, I looked that up over the weekend. But Katie can probably answer better because I would not remember the details.
What does it say in
but-
section 504 of the title?
I'll pull it up for you.
Okay,
I don't have a great answer, but I bet the health department, let me pull it up. 504.
and the health.
The other one,
I'm just going
Yes.
to mention the health department has provided written comments. We asked them to testify and they provided written comments.
It includes unattended deaths. It does not have to be criminal if they think it was not a natural death. So there are various things, but it's I didn't think it was just the Attorney General as opposed to the state's attorneys also. But
504, when the state's attorney of a county on the order of a superior judge or the attorney general for use in criminal cause pending in the state attorney's office request an expert investigation, chemical or pathological, of a substance, such investigation shall immediately be made at a laboratory without charge to the state.
there are other occasions that an autopsy can be addressed. So this section doesn't cover
All of them.
504
All of
is
them.
not, which is interesting.
Right. Okay. Well, I think we'll have some questions for Judge Zone. We are trying to get him in next week.
and second point, if I can, Madam Chair, is just to sort of reinforce your initial question about this list for things to consider. And it is listed as an and, so all of them,
Mhm.
I would think there would be in many, not most circumstances, whether the disclosure is necessary for the public evaluation of governmental performance, I would think would come up only in the rare instance. So is that already sort of a factor weighing against a request because that doesn't factor into it? I don't know. But I guess I raise that as something for maybe further
Judge Zoning.
questions.
It's like if there isn't one, then the judge would say, no, this factor doesn't play in here. If they're looking at all the factors.
Okay, any other questions for Katie? Okay, thank you. And we have Senator Hardy here because it was her constituent who this legislation is at the behest of, and she has a little bit more to the backstory. So welcome, Senator Hardy.
Thank you very much, Madam Chair and Committee. Thank you for having me. I'm Senator Ruth Hardy. I represent the Addison District. And as the chair mentioned, this bill came about after talking with a constituent who was referred to me by our local domestic and sexual abuse prevention program, Atria. This is not my story to tell, but I think she will be happy to come in and testify in person to tell you the story about why she wanted this legislation. But suffice to say, it came about because of a family tragedy that resulted in the death of her daughter, her adult daughter, who had children who were the children of the daughter who died, and their father was not in the picture. But after the daughter's death, he came into the picture and proved his parentage and gained custody of the children. Prior to that, he had not been in their lives. And when that happened, the autopsy report, there's a list order of people who get an autopsy report. And when that happened, the mother of the woman who died who at that time had temporary custody of the two children, she would have been the one to get the autopsy report. And when the father came back into the picture, he bumped ahead. Technically, actually, the children bumped ahead, but because he was the legal guardian or parent of the minor children, he got the autopsy report, and did not want to share it with the woman's mother. And it's a complicated and sad situation that may or may, that where there was a suspicion of domestic violence, and that's why Atria was involved. And but I'd rather that she tell you what she feels comfortable telling you. But she came and asked for a number of things that she was concerned about relating, grandparents' rights and parental notification and lots of different things. But a lot of them were not, especially in the grandparents' rights realm, not possible because of constitutional decisions about parents' rights versus grandparents' rights. So this was one thing that felt possible, so that there's an avenue for somebody who is not able to get an autopsy report for various reasons to have a way to go to a probate court and ask for the report with guardrails, et cetera. So I'm not on the Senate Health and Welfare Committee anymore, so I didn't work directly on the language as you see it. I introduced the bill and worked on it initially. I know they made some tweaks to the language, I think, at the request of Judge Sone. And I'm happy to hear you're going to dig into all of those things, as you always do, because they're possible improvements that could be made to the bill. But that's the backstory about why it happened. And it seems to me that there are other instances. It's not going to help my constituent, unfortunately, except for, I think, to give her a sense of feeling like she did something. Sorry, I'm going to tear up. I spent a lot of time talking with her about it. A feeling that she did something to honor her daughter and made a change to the law. So I appreciate you taking it seriously. And but there are other instances that I think it could apply. And I believe the chair, maybe the whole committee, got a note
Yes.
about it. So I do think there are other ways that would be relevant. So I just thank you for the good work that I'm sure you'll do on it.
Thank you, Senator Hardy. Is there any questions for the senator? Thanks very much.
Great, thank you very much. Have a great weekend. Get home safely.
Yeah. Why is it sticking?
Sure, yeah.
Yeah.
Don't get me all nervous.
It's the first day of spring, believe it or not.
I know. Do something like that.
Yeah.
Okay, so let's do a couple of updates, and then we have something fun to do.
That doesn't sound good.
It's fun. It really is fun.
Oh, it really is. That's sweet.
Okay, just looking for there we go. On H 657, after a lot of questions from one representative in particular, representative. Now I'm going back and forth between senators. So anyways, it voted, H 657 voted out 11-0 out of appropriations, okay? And on 938, they voted it out, the bill voted out 10-1. And the straw poll on the amendment that we passed this morning was 11-0. So both of our bills will be on notice on Tuesday and up for Wednesday, okay? So Jubilee has double duty. So
Major.
Busy this weekend.
yeah. So Representative McGuire and Representative Gill will be reporting on 938. And then I'm not sure if Dan, are you
I'm
participating
happy
in
to
this
help
or
if you
not?
want me to and do that section.
What?
Sure,
Okay, so.
we can talk.
So the
Yeah.
three folks there will be voting on that. Reporting on that. I'll report on the amendment that we passed this morning. We are going to continue our work on pre-K next week. Still working with JFO to get them in. We have the principals, association, superintendents, and, school boards coming in on Wednesday. Laura, what are we doing on Tuesday? TBD, okay, after our discussion. What'd you say? Did you want to say something?
I was distracted for a minute, so
Yeah.
maybe you already said this. We have an amendment on 657 we need to.
Yes, we do have an amendment on 657, so that's
Number
one thing,
pieces.
that's one thing we'll be doing on Tuesday.
Our own, I mean, one possibly from the whole committee. It's not,
Did we
it's not somebody else.
decide
We don't have a draft yet.
Is Jerry going to do that or just put it in ours?
The only thing they want to do is
That
keep
yeah.
the meeting our intent, but just fixing the legal
Yeah.
language. So we're just going to put it
Put
in
it right in
ours.
ours.
Yeah,
That
I
makes it more
copied you, but.
simple. Yeah,
Yeah.
yeah, I haven't.
Yeah.
Yeah,
So because that's all, because that's all they want to do, it just made sense to just combine it.
Yeah, perfect. No, that when we presented it here.
and then we had the ADA coordinator bill. They have passed that out of House appropriations with that sort of interesting language that says if money is appropriated. What is we had talked some about, an amendment allowing them to, apply for and receive grants to further their work. Is there, any interest? Is there anybody who wants to take that on? Because it doesn't have to be a committee memo, a committee amendment.
Oh, I see.
No. I think it's good practice.
Get to that.
Are we assigning that to
You
Doug?
could just assign it.
Or- Yeah.
Either one. Doug's not here. You
There
said.
you go.
Do it. I don't mind doing it.
Was the vote.
So we were just talking about the ADA amendment. Excuse me, the ADA coordinator bill that we have. It has now been tongue-tied.
It's Friday.
Has now been voted out of appropriations with that sort of weird language. So it is possible that it will be funded. We had talked about an amendment that enabled them to apply for grants and receive grants to further their work, since it's a job that's bigger than one person. And so because you were absent, Representative Issa suggested that you would be the person to do the amendment.
My former friend from.
Dan is also happy.
Dan is also volunteered, so. I'm not volunteering. I have to work on a one pager for the 938,
If
so.
Representative Noyes, because it was taking me a moment just to even know this was this week to catch up with what you were talking about. If you're feeling more.
Okay.
Work with
Breaking
Katie.
news.
And I'll bring a copy of it.
We have a new DCF commissioner,
Oh, who is it?
Sandy Hoffman.
Oh. The current commissioner.
I will say some breaking news. I've heard word on the street is that starting, it's a topic and we cover it in this, the number of, Human Service Board,
Appeals.
appeals that have happened around this, when do days start over and all of that. So they've announced, that they'll be restarting the clock on July 1st, is my understanding. So took 400 appeals.
Oh my God.
Wow.
Yeah. Okay.
I missed the 938 was what for the vote? I missed.
Out of appropriations,
Yeah.
on the bill, it was 10-1.
Zero.
On our amendment that puts out the money, it was 11-0. It was supported by all on the committee.
Okay, wait. So 938 was 11-0?
On the amendment,
And with the dollar breakout.
the one that we voted on this morning, Brenda, that you made the statement about, that was 11-0.
Appropriations with the dollar amount?
11-0. The amendment voted 11-0. On the bill itself, it was
Okay.
10-1. The no vote was from Representative Yakavoni, because it reduces services. It doesn't reduce service, it reduces the number of people who are resource,
And then 657 was voted out.
11-0.
Thanks. Okay.
Okay, so, we're gonna wrap up pre-K next week. We are going to start to do some additional oversight and accountability stuff, with Dale. We're gonna move off DSCAT for a little while.
They'll be very relieved.
They'll be relieved.
We're
I'm
turning
relieved.
them over to the Senate.
Right. And then we're going to be talking about recovery residences as well. So, and I don't really know what the S-243 one is all about yet. So, language, justice.
Oh, I
Project.
looked at that. Yeah, it's pretty small, Bill, but it's about at times of a state emergency
Mhm.
that we need to have several language
Oh, okay. Yeah, we
language
can do that, yeah.
available,
Yeah.
messages in.
So we'll take that up maybe
Yeah.
before we do 157,
Emergency
which is going to
access
be
to
a longer
people. Yeah,
discussion.
yeah.
Okay, great. So it's been a long week. We've had a lot of floor time. And Lori, I think we can go